Buenos días. Even though I've heard Professor Gilbert's Spanish is phenomenal, we're going to do this in English. Okay, so good morning, everyone. Welcome to Universidad Ibáñez. I'm Juan Carlos Llobet. I'm the Dean of the Business School. I don't know much about law, but since we're talking about law and economics today, I thought I would be invited to give welcoming remarks. It's a pleasure and an honor to be here. I'm especially grateful for the opportunity to deliver these opening remarks at the lecture by Professor Michael Gilbert. Professor, welcome. He's the Vice Dean of the University of Virginia School of Law. Professor Gilbert will be presenting his book, Public Law and Economics, that he co-authored with Robert Cooter. Am I pronouncing his last name well? Okay. And that was recently translated into Spanish as Análisis económico del Derecho. I would like to thank Professor Gilbert for authorizing the translation of his work and to express my appreciation to the team at Centro de Competencia SECO of Universidad Ibáñez for leading this valuable editorial initiative. This book is a fundamental contribution to the field of law and economics, particularly within public law. It offers us conceptual and analytical tools to evaluate our institutions through a rigorous lens, one that focuses on incentives, costs, and the actual effects of legal norms on social welfare. Let me briefly, not more than 45 minutes, address two issues. That was a joke.
Let me briefly address two issues that I believe are especially relevant today. First, I would like to highlight the value of this book in reflecting about one of Chile's current institutional efficiencies, what we call the permisología. That would be in English like permitting or regulatory overload. As a university that is highly committed to the country's development, we strongly believe in the importance of sound public policy. Yet we are concerned about the negative impact that excessive bureaucracy can have on investment, innovation, and productivity. In several sectors, particularly infrastructure and construction, I would say, the maze of permits and administrative requirements has become a serious bottleneck. It not only delays key projects, but in many cases prevents them from materializing altogether. Gilbert and Cooter's book gives us the analytical lens to examine this issue. They remind us that institutions, even when driven by good intentions, may generate high opportunity costs if not properly designed. They invite us to consider the unintended but highly relevant consequences of regulatory excess and how these consequences can directly affect people's well-being. Second, I would like to link this reflection with one of the core commitments of our university, the need to train professionals who can integrate knowledge across disciplines in order to face the complex challenges of our time. With that goal in mind, last year, we took a major step forward by launching, as many of you already know, our new double degree program in law and business and economics. Through this innovative academic path, we aim to prepare leaders who can understand both the legal logic and the economic foundations of regulation and public policy. For these future bilingual professionals, if we can call them that way, works like the one we present today are immensely valuable. Books that not only understand law from within its own framework, but also subject it to an analysis of incentives, efficiency, and consequences. At Universidad Ibáñez, we are convinced that this is the kind of graduate profile that Chile urgently needs. In closing, I once again thank Professor Gilbert for making this translation possible and extend my gratitude to all those who contributed to its publication, especially Felipe and his team. May this be the beginning of fruitful and lasting dialogue between our academic institutions. Thank you very much.
Let me begin by expressing my thanks, and they will be share a bit about the translation project. I will be short, so don't worry. First, I want to thank Mike and Robert for their interest in making their book available to Spanish-speaking audience. I also want to thank Rubén Méndez for his support in publishing the printed version through Tirán Blanche, and the Universidad Adolfo Ibáñez through SECO for helping promote the development of law and economics in public law. This translation project started 2 years ago. In May 2023, our friend Danny Sokol suggested we take a look at the recently published book by Michael Gilbert and Robert Cooter, released by Oxford University Press on law and economics in public law. At SECO, we reviewed the book and immediately saw its importance. The combination of law and economics is common in competition law, but it also applies to many areas of public law. We were already familiar with the well-known book by Cooter and Ulen on law and economics in private law, which had a major impact. This new book brings economic concepts and methods into sensitive topics such as the creation of laws, enforcement by administrative authorities, and their review by judges. We believe that lawmakers should always evaluate different legal options based on the effects that aim to achieve, using solid evidence and keeping in mind the reality of scarce resources. The same goes for administrative authorities, who must prioritize how they implement public policy within the limits of the law, focusing on effectiveness and efficiency. Finally, judges should understand the internal logics of the law they apply and how those laws connect to their intended purposes. Our first step was to secure translation rights from Oxford University Press. Michael helped us with the funding. Once we had the rights, we began the translation work carried out by Ignacio Peralta, who is over there. You can raise your hand. With the assistance of José Tomás Saavedra and Fernanda Ruiz. The SECO team started with a first draft using AI. Then came the hard work, reviewing the text word by word to make sure it read smoothly and included helpful notes for Spanish-speaking readers working within a continental law system. In recent months, SECO has published 5 books. First was David Gerber's Global Competition Law Guide. Then came Merger Control by Fran Levin and the Statistic Manual for Antitrust Lawyer by Jorge Fantuzzi Santiago Matallana. Just a few days ago, we launched another book at CEP, a compilation of economic reports by Alex Galetovich and Ricardo Sangüesa. Let me briefly introduce Michael. Michael Gilbert is Vice Dean and Per Bowen Professor at Law at the University of Virginia. He teaches courses on election law, legislation, and law and economics, and his current research focuses on misinformation, corruption, and the role of pro-social preferences, such as empathy in law. I don't know what's that, but sounds interesting. His research was appeared in multiple law reviews, peer-reviewed journals, and edited volumes, and he has lectured throughout the United States and around the world. Once again, thank you for your interest, and I invite you to visit the book website and download Mike and Robert's book.
Well, thank you very much, Felipe, for the introduction. Thank you to the Dean. Thank you, everyone, for being here. It's really a pleasure for me to have an opportunity to visit Chile and to talk about the book. It is an honor to have had the book translated by this excellent team into Spanish. It means a great deal to me and also to my co-author, Robert Cooter. Thank you. Grateful. So, as Felipe mentioned, the title of the book is Public Law and Economics, and I'll tell you about that. But first, very briefly, I want to talk about private law and economics. The economic analysis of law has been enormously influential in the United States and in many places around the world for over 50 years now. It has just been 50 years since Richard Posner published the first edition of his influential law and economics book. Of course, for most of those 50 years, economics has been successful as applied to private law, contracts, property, torts, and so on. It has had much less success in the United States and elsewhere in public law. I don't mean that there isn't any research or work that could fairly be characterized as being about public law and economics. What I mean instead is when public law lawyers, when judges deciding public law cases do their work, they don't think naturally of economic concepts in the way that lawyers doing private law and judges doing private law do. Why is this? Well, my co-author and I have some different hypotheses for why it has been less successful in the public law space, and I won't bore you with all of them, but I'll mention two. The first one is that much work on public law or at the intersection of public law and economics is produced by economists, particularly economists in the United States. It's very technical. If you don't have a PhD in economics, if you're not an expert in calculus and game theory, you can't understand it. And this is a problem. It's impenetrable for many lawyers and judges. The second problem is this, as you all probably know very well, the normative foundation of economics is efficiency. That's what we're trying to maximize. In many circles, particularly legal circles, including in the United States, there's a deep misunderstanding about what efficiency means. People think it means money and nothing more. So they say, well, with respect to contract law, it makes sense. Business law, the parties are trying to make money. You can use an efficiency framework in this space. But it doesn't work in constitutional law. It doesn't work in regulatory law because these are not focused on money. These are focused on rights. They're focused on justice and so on. Okay, this is a deep misunderstanding of what efficiency is. Efficiency means the satisfaction of people's preferences, whatever those preferences happen to be. So frequently, people have preferences for more money. That's not surprising, particularly in business law, contract law, whatever. But economics is not so limited. You can have preferences for equality. You can have preferences for justice. I have the challenge of defining justice. You can have preferences for anything, and we can pick up these economic models and use them. And I think they're very powerful. Okay, so Robert Cooter, my co-author, and I, we decided we want to try to overcome the problems, including the two I just mentioned. So we worked for many years on this book, and the goal is to produce some new insights, but also to take existing insights and package them and present them in a way that we hope is clear and useful and accessible. There is no calculus in the book. There's no very little game theory in the book. The hope is that the ideas will be clear and straightforward. We also spend many pages trying to correct this misunderstanding of what efficiency really is. Okay, so here's the book, the English version, published by Oxford, open access. I'm absolutely delighted now that Seiko has produced the Spanish translation. I think it's now available on your website. Thank you again. It's really an honor. I hope it will be used, and I hope it will be helpful. So let me talk a little about the structure of the book, and then I'll turn to some specific topics. So public law is huge. Public law encompasses everything from the separation of governmental powers and human rights, bound topics, to, on the other end, speed limits for your car and a requirement that you wear a seatbelt. Okay. We couldn't write a book that attempts to go topic by topic, public law. So the approach we settled on instead was this. The book is organized around fundamental processes of government. We think there are 6 of them. We think that there is a quite useful and sophisticated economic analysis of each process. And we think that if you understand that economic analysis, if you understand the processes that produce public law, you will have a lot of insight into the public law itself. So just very briefly, let me run through them. Bargaining is everywhere in government. Legislators bargain to enact bills, judges bargain with one another over the content of their opinions, and the list goes on and on. We study bargaining extensively. Voting, of course, is very common in government. Citizens vote to select their lawmakers. The lawmakers vote to enact their bills. The judges or panels of judges vote to decide cases. If you understand the economic analysis of voting, many parts of law make more sense. Oops, sorry, not yet. Okay, a third fundamental process, entrenchment. You're all familiar with this. Some laws are relatively easy to change, but others, like our constitutions, we entrench. It's difficult to change them. That's by design. Why? When does it make sense? When should we entrench? When shouldn't we entrench? And so on. Economics can help us understand. Delegation, of course, government, especially in democracies, features long chains of delegation. The citizens are really the principal, but we delegate the government to some lawmakers. Why? Because the transaction costs are much too high for us to do it ourselves. So we delegate to some officials, you know, the president, the legislature, etc. But of course, they can't do all the work themselves. They delegate to committees, to agencies, and the list goes on and on. Delegation is common in the judiciary in a slightly unusual way. Ordinarily, when we think of delegation, principal agent scenarios, we think that the principal has the power to fire or discipline the agent. In judicial hierarchies, that maybe isn't true. In the United States, many other places too, the high court judges cannot fire the lower court judges. They don't do what the high court says, but there are various mechanisms of influence. Adjudicating, I'll come back to that one. And finally, enforcement. You all know very well, enforcing the law is very difficult. It is expensive. It's a challenge. Enforcement works through multiple channels. They sometimes work against each other. We have an analysis of enforcement. Okay, I'll come back now to adjudicating. There are many topics in the book under these different processes. And Felipe suggested that I focus on this category in my brief time with you today, adjudication. Of course, adjudication is fundamental to public law. There are many topics that fall under our discussion of adjudication. When should you sue? When should you settle? There's a discussion of how judges decide cases. There are different models here. Do they decide based on the law? Do they decide based on their ideological views? Are they engaged in a strategic game with one another? And so on. I'm not going to focus on those topics, though. Instead, I'm going to focus on something which is interpretation. So, of course, if you're trained in law or spend time around lawyers and judges, you understand this very well. The words of the law, statute, the Constitution, the regulation, these are just the first step. A famous judge in the United States has an old quote that I really like. Words are but the skin of a living idea. Okay, I read the words, but now I need to know, yeah, but what does it mean? And this is where the lawyers come in. This is where the judges come in. You have to interpret the law to make sense of it. Okay, in the United States, we have a long-running and I think sophisticated, not conclusive, but sophisticated discussion about interpretation, with many people taking different positions on how best to interpret the law. So I'll talk to you now about two main schools of thought around interpretation. One that is referred to as textualism, and the other that's referred to as intentionalism. You may be familiar with these distinctions, I don't know. You probably know them even if you're not familiar with the vocabulary for them. So I'll describe them abstractly or briefly, and then I'll give you some cases to try to make the points clear. So the basic idea of textualism is that the law means what the text says. Very simple. You want to understand the law, you read the text, and nothing more. This is meant to pursue further certain values like predictability and notice in the law. If ordinary citizens want to know what the law requires of them, they can simply read it. They don't need to know more. Intentionalism, in contrast, says, no. The meaning, the correct meaning of the law is what the legislators who drafted it intended. It's what they were trying to achieve. Now, sometimes, frequently, what they were trying to achieve is also what they said. So textualism and intentionalism are the same. But sometimes that's not true. Sometimes the words are ambiguous or they're vague. You can't quite make sense of them. How do you resolve a case in that circumstance? Well, you consult the intent. What were they trying to achieve? Let me tell you about some cases. I'll get to the economics soon. But first, a little more law. I'll give you some recent cases, or not recent, but interesting cases that are studied in the United States that help to distinguish these different schools of thought. So let's start with a case that has a very boring name. So I will just call it the school bus case. We don't need to know the real name. So in my home state of Virginia, there's a statute, and the statute says, we will punish any driver, here's the language of the statute, who fails to stop when approaching from any direction, any school bus which is stopped for the purpose of taking on or discharging children. Okay. A man with the last name Mendez is it wasn't Ruben, is approaching a school bus in Virginia. The school bus is stopped. The lights are on. The children are getting on the bus. He drives right by, and a police officer tickets him. And instead of just paying the ticket, he goes to court. And he says, I did not violate your statute. Do you see why? This is difficult if English is not your first language, I know. But there's a very important little detail in here. The statute is missing a word. It doesn't punish any driver who fails to stop at a school bus which is taking on children. It punishes any driver who fails to stop a school bus that is taking on children. You see the difference? Read literally, the statute says your job is to stop the bus, not yourself. You don't have to stop, you have to stop the bus. Okay, there's an old word for this, a Scrivener's error. It's a typo. They forgot something in the statute. Okay, so what do you do in this case? Well, if you're a very committed textualist, you might say, you didn't break the law. If you're an intentionalist, what do you say? Everybody knows what this means. Everybody knows what they intended. You broke the law. What do you think the judge did? No violation. Textualist. Strong textualist. Many strong textualists, even here, they would say, no, you broke the law, but not this judge. Okay, I'll give you another example. This is a famous one from the US Supreme Court, a case called Locke. There's a government regulation, and it says if you are a miner, you're digging things out of the ground, on public lands, the government wants to keep track of where on these public lands you're working, and you have to file paperwork with the government, here's the language of the law, prior to December 31 each year, or you lose your mining claim. Well, you can already see what Mr. Locke did. It's obvious. He filed his paperwork on December 31. Well, on the one hand, you say you're a day late. Sorry. On the other hand, why would the government want the paperwork on December 30? It seems so arbitrary. Surely they meant to say by close of business on December 31, or on or before December 31. No one in the case, this got all the way to the US Supreme Court, no one in the case could generate any reason for making the deadline December 30. Furthermore, the language is just very strange. Obvious. If you want the deadline to be December 30, say December 30. Why would you say prior to December 31? Well, you can see how different schools thought. Wow, the textualist says, sorry, you're a day late. I read the text. The intentionalist says, no, this was an error, December 31. What did the judges, the court in the US do? It means December 30. You're a day late. You lose your claim. The mining claim was worth about $1 million. Now that cuts both ways, no? On the one hand, you say, wow, it's a big loss. On the other hand, if you have a mining claim worth $1 million, hire a lawyer. The lawyer will read the statute and say, let's say December 30 to be safe. Okay, I'll just tell you about one more. This is a very famous case. in the United States and elsewhere. It's studied in legal philosophy frequently. It's a case called Riggs, real case from the state of New York in the 1800s. It's an amazing case. So the grandfather writes a will, and he will leave in the will many things to his grandson. Okay? Then, after the will is written, the grandson starts doing things the grandfather does not like. The case does not specify, but he's a young person, he's getting in trouble, who knows? Okay, so the grandfather says to the grandson, you better improve your behavior or I will take you out of my will. What does the grandson do? He kills the grandfather. He murders him, he poisons him. Okay, he gets in trouble. He goes to jail, whatever, you know. The question in the case is about the will. Does the grandson get the money? The will leaves everything to the grandson. Okay, well, there's a statute in the state of New York that addresses wills. Here's the language from it. No will in writing, except in the cases hereinafter mentioned, nor any part thereof, shall be revoked or altered otherwise. This is somewhat old language, but the basic idea is the will means what it says, except for some very narrow circumstances that do not cover murder. So what do? Well, you can see the conflict again. We have the textualists who say, or who you might predict say, he gets the money. That's what the will says. That's what the statute says. And you can imagine the intentionalists who would say, whatever they were thinking, these legislators, when they wrote that statute, they didn't mean for murderers to inherit. Okay, who won in this case? The intentionalists. They said, you can't inherit. We don't care what the statute says. But there's a dissenting judge who says this is the wrong decision. Our job is to apply the law correctly and fairly, and the law's clear. It's not just, but it's clear. We should do what the law says. Okay, it's easy to imagine people fighting over textualism and intention. What is the best way to interpret law? What is the correct way to do it? Okay, well, in the book, Robert Cooter and I, we attempt to make a kind of economic contribution to this very old debate. And the bad news is we don't think we have a solution to this debate. There's a reason people have been fighting about this for millennia. Plato wrote about law and its exceptions. But we do think that with economic analysis, we can at least sharpen the debate. We can see some trade-offs, we can see some costs, we can see some considerations more clearly than we otherwise would. So we break down, sorry, that's small. I don't know if you can see it, but the idea will be clear enough even if you can't see the numbers. So we think about this trade-off between textualism and intentionalism in terms of a few different kinds of costs. Very difficult to measure in practice, but it perhaps conceptually helpful. So first, communication costs. Most of the time, when we're communicating information, we want the listeners to understand us. Most of the time, if you're listening to information given by someone, you want to understand that information. This is how exchange or communication happens all the time. We think, of course, the same phenomenon operates in law. When the legislators make laws, they want to be understood by the regulated parties, and the regulated parties, they want to understand the law that they've been given. The problem arises when you're surprised, did not realize how the law worked. So in this way, we can use a simple but powerful concept from economics to think about legal communication, coordination games. You may all be familiar with coordination games. Here's the classic and simple example, but helpful. Which side of the road should we drive on? The right or the left? And most people's answer is, I don't care, as long as we all make the same choice. We all drive on the right, we're fine. Left, we're fine. The problem arises when some people choose right and other people choose left. Then we have our accidents. Okay, that's a classic coordination game. Now we can use that concept to think about communication in law. So what this simple little matrix is showing you is, or imagining, is a communication between the lawmaker and the citizen. And in our simple setup, the lawmaker is either giving or denying permission to the citizen to do something. So for example, you want to dig a mine on public land. Does the law let you do this? Yes or no? So the lawmaker sends some signal, yes or no, and then the citizen understands the signal, yes or no. Okay, in the top left box, we're capturing a scenario where they both the lawmaker sent the signal yes, and that's what the citizen understood. This is coordination. The communication works. They both get relatively high payoffs, 5 and 5. Same if we're in the bottom right. If the lawmaker says no and the citizen understands no, we've coordinated on meaning. No one is surprised. We're fine. The other two boxes, of course, these capture the problems. This is when the lawmaker says, no, you can't build, but the citizen understood the lawmaker to say, yes, you can, or vice versa. This is when we have the miscommunication. This is when something has gone wrong. Okay, so with that basic setup in mind, then we study two scenarios, one that we call a minor misunderstanding and one a major misunderstanding. So to explain, a minor misunderstanding is a circumstance in which the lawmaker has sent the signal and most citizens have understood it correctly, but not all. So perhaps one citizen, let's suppose the signal was, no, you can't do this. And most citizens understood no to be the answer, but one citizen makes a mistake and thinks the answer is yes. So that citizen has now dug a mine on the public land and they're in trouble. They're not allowed to do that. Okay, so how do we think about, and now you get your case, right? Now you get a case and the question is, well, what does the law mean? Maybe the text and the intentions push in different directions. Okay, so in the case of minor misunderstandings, what Cooter and I argue is that there is already an equilibrium. There's an equilibrium in the sense that the lawmaker and most citizens have coordinated. Whether it's on yes or whether it's on no, doesn't matter, they've coordinated. There's just one person or a small number of people who are in one of the diagonal boxes. Okay, so now let's think about how to resolve this case in terms of communication costs. That is, how easy or hard it is for the lawmaker and the citizens to communicate. If the judge decides in favor of the citizen, yeah, you can build the mine. It's fine. The judge is breaking the equilibrium. The lawmaker sent this signal. Most citizens understood it, just one or a small number didn't. If you side with the one or the small number, you're scrambling the equilibrium. And that increases communication costs. It's now hard. It was working before. And now you've made it harder for the lawmaker to send the signal. They'll have to do something different. And you've made it harder for most citizens to understand the law. They understood it before, and now they don't. Okay, so in the case of minor misunderstandings, even if it yields an unjust result, come back to that. For purposes of communication, no. Enforce the existing equilibrium. That will minimize communication costs, even though it means this person loses and may lose a lot. Okay, now let's contrast that with a different kind of scenario, one that we refer to as a major miscommunication. So the idea here is that the lawmaker has sent a signal, but lots of citizens have failed to understand. So for example, we'll go back to the lock case. The lawmaker has sent a signal that says you must submit your papers by December 30. It's a confusing signal, but that's the signal, December 30. But lots and lots of citizens, they don't understand this. They think it means December 31. Okay, so what do we do here? Well, when there's a major misunderstanding, we can't really say there is an equilibrium. They have not coordinated on meaning. You sent this signal and many citizens, most citizens, whatever, they understood something else. Okay, so if there's no equilibrium for a judge to find and enforce, instead, the judge has to make an equilibrium. They have to just decide, well, this is the signal or that's the signal, and now everyone has to get in line or you get in trouble. Okay, so then we ask ourselves, in terms of communication costs, how should they do it? There are really two options to think about. If the lawmaker, you can either say that the signal the lawmaker sent, that's the law, so you side with the lawmaker, or the judge can decide that the signal the citizens received is the law, and so you side with the citizens. It may not be what the lawmakers want. Well, too bad. The equilibrium, now everyone's on the same page. Now we all understand the law means what the citizens thought it. Okay, so let's think about communication costs given these two options. If you side with the citizens, you've just made communication harder for the lawmakers. They have to do something different. We tried to say December 30. That's what we tried to do, but the judge said we can't, or at least we can't do it that way. We have to go back and communicate differently. We want the law to mean what we say. If you side with the lawmaker, well, now you've increased the communication costs of the citizens. They thought they understood what the law meant, but now the judge tells them that's not what it means. It means something else. Oh, so if you take the lock example prior to December 31, if you side with the lawmakers, what you're telling all those citizens is you must read very carefully. Don't use your intuition about the deadline. Read the statute. Now, for the people in this room, maybe we say, okay, that's not so hard. But for many people, that is hard. Where do you even find the statute? And when you find it, can you really read it that closely? And okay. So no matter which decision you make, no matter which equilibrium you choose, you're raising communication costs for someone, either the lawmakers or the citizens. What's the optimal choice? Well, I wish I had a clear answer for you. Only a framework for thinking about it. In the immediate case, it seems to Cooter and me that the answer must be you should side with the citizens, because there are many, many, many citizens and relatively few legislators. So if you side with the citizens about the meaning of the law, what you're telling the legislators is you need to do something different to send the signal you want. Okay, there's not that many legislators, you just enact a new law. It's not costless, but it's less costly than requiring thousands or millions of citizens to change how they read the law. So in the immediate case, this is easy. But of course, in law, we think about the run of cases, not just the single case in front of us. And in the run of cases, this is harder. So this is a very simple matrix just to capture some of the discussion we're having. So suppose we have the lawmakers on one side and we have the minors on the other, and they're trying to coordinate on the meaning of law, and they can either coordinate on the text or the intent. Okay. So if they coordinate on text, they both understand the law means what the words say, even if it's clumsy. And if they coordinate on intent, then they both understand the law means what the legislators meant it to mean. And again, the problem comes when we think it's text and you think it's intent, vice versa. Okay, so for the sake of example, we've just invented some numbers. Let's suppose that we have our major misunderstanding and the court is going to choose an equilibrium and say intent. Okay, the law means what we understand the legislators to have intended. The text is less important. Okay, for the sake of example, that's the bottom right box. We say both of the parties get payoffs of 5. Now the question is not in the immediate case, but in the run of cases, what would the payoffs be if instead the judge selected text as the equilibrium? Look, the law means what the text says. So let's think about what that would mean in the run of cases. It would mean in the immediate case, the deadline is December 30, because that's what the text says. But in the run of cases, it means minors, you have to read the statute. Stop using your intuitions, stop thinking about intent, read the words carefully. Okay, well, here you can see we have punted. We say, well, the payoffs now are X. We don't know the value of X. It could be greater than 5, in which case the equilibrium you should suggest is textualism. But of course, it could also be less than 5. It could be worse in the long run for communications to coordinate on text. The basic trade-off is one I've already begun to describe. The problem with intent, the reason communication costs associated with intentionalism may be high, is that you don't know the legislator's intent all the time. I don't know what they meant, obviously. On the other hand, sometimes you do. Think about the school bus case. I know exactly what that statute means. And so did Mr. Mendez when he drove past that bus. Sometimes our intuitions are very helpful. And with intentionalism, we can use them. With textualism, not necessarily so. Okay. I want to give you one more little, this is now just brief, more law, but it relates to economics. Many people believe that in the long run, on my last chart here, X must be greater than 5. That is to say, look, in the long run, communication costs will be lower, all things considered, if we coordinate around text. Because then all you have to do is read the words of the statute. Personally, I'm quite drawn to this idea, but I can't prove it to you. It's just my intuition. For the sake of, academic discourse, let me give you some reasons to think, yeah, maybe it's not true, actually. Coordinating on text is hard. So let's consider this statute. Anyone possessing guns, knives, or arms in a public library shall be punished. Now let's suppose you have this question. Can you carry a baseball bat into the library? Okay. If you're a textualist, this is not an easy question. Because now you focus only on the language of the statute and you say, well, a baseball bat is not a gun or a knife. I know that. Is it an arm? Well, lawyers have a field day here. These are arms. Of course, baseball bats are not arms. No, that can't be what it means. When it says arms, it must mean something else. Okay, so how do judges in the United States, in the UK common law tradition, how do they try to answer a legal question like this? They use canons of construction. Maybe you're familiar, I'm not sure. The basic idea is they're little tips and tricks to help you make sense of language. So just briefly, I want to review some of these for you. So one canon is just the principle of ordinary meaning. The law means what it says. Textualists like this canon for obvious reasons. The problem here is it doesn't really help you. Right? The question is whether a baseball bat is an arm. It could be. You can hurt people with a bat. Okay. Here's another canon with a Latin name, noscere sociis. So here's the idea of this canon. In a list of terms, you have one term in the list, in this case, arms, the meaning of which is not clear. You should use the other terms in the list to help you make sense of it. Okay, so the other terms in the list are guns and knives. So what does arms mean? It doesn't mean this, clearly. It means that noscere sociis tells us that. It must mean something else. Okay, well, maybe it means anything you can hurt people with. In that case, a baseball bat would count. But here's we have another canon, the presumption against superfluity. Every word needs to mean something distinct. It has to. If you allow judges to say, oh, no, the word arms just means the very same thing as knives, then what you've done is allow the judge to just delete part of the statute. They're just saying arms doesn't mean anything. Well, that can't be right. Okay, so arms, whatever it means, it has to be different from guns and knives. We have yet another canon, the rule of lenity, which says, look, if you're not sure what the criminal statute means, just rule in favor of the defendant. If the rule's unclear, we're worried about overreach by the government, just rule for the defendant. Well, this is a very simple statute that I made up for the sake of example. And just this statute implicates many canons. Now, who uses these canons? Textualists. This is how you make sense of the text. You need to use all these tips and tricks and tools to try to iron out meaning. Okay, so now ask yourselves, you probably don't know these people, but you can maybe imagine all the miners in the United States digging up minerals on public lands. Do they know the canons of construction? No, of course not. But textualism requires them to. I just use this to show you the point. Sometimes maybe intentionalism actually comes with lower communication costs. What might an intentionalist say about this statute? An intentionalist might say, look, I don't know exactly what arms means, but I do know this. I'm quite confident the legislature was trying to stop people from taking weapons to the library. And although your baseball bat can hurt people, it's not a weapon any more than your soccer ball or your cleats or your helmet for playing football. Intentionalists might have an easy answer to this. Textualists, this is going to take a while. Okay, so as I said, I can't tell you the answer on communication costs, but in the book, we try to think it through systematically and just help identify some things to consider. Okay, here's another dimension to the problem. We consider transition costs. So anytime law changes, someone is almost certain to bear a transition cost. I want to be clear, a transition cost does not refer to just the change in policy. I like the old law, I don't like the new one. There's a cost to that too. You don't like the policy. But by transition cost, we mean something else. It's just the costs of adapting to the change. So here's an example, a very simple one. In my state, in many states, many places, there's a sales tax. So every time you go to the grocery store and you buy bananas and soda or whatever, you pay the price, plus there's a tax on top. Okay, every time the legislature changes the sales tax, every cash register in the state of Virginia has to be reprogrammed. Every time. Doesn't matter if you change the tax a lot or a little, every one of them must be reprogrammed. That's a transition cost. It takes a little bit of time, thousands of people across the state to update their cash registers. Well, economists take all costs into account, so we worry about transition costs, including in interpretation. If the judge, through interpretation, changes the law, there's likely to be some transition cost associated with that. Okay, so how do we think about transition costs in interpretation? Again, for the sake of our brief discussion today, we ask which of the methods we have covered, textualism or intentionalism, is likely to minimize transition costs. And here I'll use the concepts I mentioned before. Imagine two scenarios: a minor misunderstanding. Mostly everyone understands the law. Maybe one person or a few people, they don't. Versus a major misunderstanding. Okay, so with a minor misunderstanding, this is relatively easy, we think. This is important. It's relatively easy, even though we can't actually measure the transition costs with any specificity or certainty. Our intuitions can help us a lot. So let's think about the school bus case. You remember, he drives right past the school bus, endangering the lives of children. And the problem is the law has an error. It doesn't actually forbid what he's just done. So how should the judge resolve this man's case? You can be a textualist, no violation, or you can be an intentionalist. Yes, clearly you broke the law. We know what they were trying to achieve. Well, if you rule against Mr. Mendez, only one person has to change their behavior, him. He has a transition cost. I guess I have to stop at the school bus. If you rule in favor of Mr. Mendez, many, many, many people have to change their behavior. Everyone who drives a school bus, every parent, they all have to worry and react to or respond or take action to prevent risk to their children that otherwise would not be present. Okay, so for transition cost purposes, this is easy. Rule against Mr. Mendez. The intentionalist decision here is best. Okay, we can make a similar argument about Riggs. Remember, this is the famous case about the grandson who murders the grandfather. Does he get to inherit or not? If you say the answer is no, you can't inherit. This is the intentionalist interpretation. Who has to change their behavior? The presumably very small number of people who were planning to commit murder to inherit. What if you decide the other way? The textualist decision. It doesn't matter if the person murdered you. If your will leaves them the money, they get the money. Well, now, everyone with a will in the state of New York is going to call their lawyer and say, I need to change my will. I'll give the money to Pablo unless he kills me. Then I give it to someone else. Okay, so again, with a minor misunderstanding, most people understand. Of course, you can't inherit if you're a murderer. The answer for transition cost purposes is pretty clear. You rule against the person the small number of people who didn't understand the law. With a major misunderstanding, of course, this is much harder. So remember the law case, are your documents due on December 30, or can you submit them December 31st? Any way the court decides this is going to create transition costs. If you decide for the minors, then the government is going to have to change not only how it communicates the law, but how it processes the papers and when it processes them. You've changed the deadline. If you do it the other way, if you decide in favor of the government, well, now you're imposing transition costs on the minors. They have to change their schedule. When do they file the documents? When do they collect? There are transition costs either way. With a major misunderstanding, it is impossible to say in the abstract which approach will minimize transition costs. Okay, I'm okay on time. Okay, if I go too long, just, wave at me, please. Let's talk now about justice. Okay, so most people, including many lawyers, when they hear summaries of the cases I just described, they don't care about communication costs. They don't care about transition costs. They care about justice. The man who sped past the bus should go to jail. The kid who murdered his grandfather does not get the money. I don't care what the statute says. We do what justice requires. Justice is, it has an allure that economics does not. I understand. Okay. Well, do we make exceptions to the law to promote justice? This is closely related to intentionalism versus textualism. If you're a textualist, you're likely to say no. If you're an intentionalist, you're likely to say yes, we make an exception to the law to promote justice because the legislators probably would have wanted that. It would have been their intent. Economists do not have a theory of justice. Justice implicates all kinds of values, or it might, that philosophers disagree about and that economics as discipline does not have a strong view on. Some people, economists, take the position that justice just means efficiency. This isn't completely crazy. Remember, efficiency doesn't mean money. It means the satisfaction of people's preferences, whatever they are. But still, in my experience, many public law lawyers and judges and philosophers, no, they reject this equating of efficiency and justice. So what, as law and economics scholars, what do? We could resist them and say, look, we don't care about justice. We ignore you. We're doing efficiency. I think this is not the right approach. And my co-author agrees. If we want economic analysis to be influential in public law, we have to accept some of the commitments of public law. And many public law lawyers, for perfectly natural reasons, and scholars and so on, they have a commitment to justice. Okay, so we want to allow for the possibility that justice is the goal of the law. Without a theory of justice, we don't have a lot to say about that, but we can say a little. Justice, in our view, relates to information. The question, as Cooter and I put it, is this: who has the information to know what is the just result in a given case? Okay, so those are the points I just made. And here we think it's helpful to distinguish two different kinds of facts: legislative facts and adjudicative facts. Now, the boundary between these types of facts is a little porous, but still there's something to the distinction. So legislative facts might be quite helpful and detailed, but it's general information about a policy issue. Whereas adjudicative facts are facts about a particular case or controversy under the umbrella of that issue. So let me give you a couple of examples. Suppose you're trying to regulate, this is from the book, suppose you're trying to, as a legislator, regulate a new mine. This is our theme for the day, mines. Okay, well, you have general information about how profitable the mine will be, what products will result from it. Maybe your country needs the products for national defense, but you'll pollute the groundwater. Okay, these are legislative facts. They're all the considerations that influence the creation of public policy. Now, suppose there's a mine and it accidentally leaks poison into the groundwater and some people get sick or die. And now there's a case. Well, all those details are adjudicative facts. They will come out in the case. And the legislators who enacted the law to regulate this mine, they didn't know any of those facts. They couldn't have at the time they decided. Okay. Let's see if I have. Yes, let me give you one more example of the distinction. This relates to the Riggs case. So when the New York legislature enacts the statute of wills, they have general information about how people write and use wills. When the Riggs case came before the New York court, well, that court had adjudicative facts. It knows something now that the legislators couldn't have, which is that the grandson was going to kill the grandfather. Okay, so you see, different kinds of facts. Okay, to make the just decision, you need to have the right facts. You need to have the right or the best information. A circumstance could arise in which the legislature has better legislative facts and actually better adjudicative facts. Maybe they could anticipate the kinds of cases that would arise. Well, if the legislature's information, both types, is better than the court's, then you should do what the legislature wanted, not create an exception to the law to promote your own judicial sense of justice. They're in the best position to know what justice requires. Of course, it could go the other way. You could have a case where the judges not only know the adjudicative facts better, but they actually have better legislative facts. They understood some things that those part-time, unprofessional legislators, they didn't know or they didn't think about when they crafted the policy. Now the case for making an exception is stronger because the judges have the information. Of course, the more challenging case, and it's probably the common one, is when the legislature has better legislative facts, the adjudicator has better adjudicative facts. Okay, do you make an exception to the law in this case for the sake of justice? It's impossible to give an abstract answer, but we can at least see the trade-off. Are the gains in information terms from the adjudicative facts that the judges possess greater than any losses associated with acting contrary to the legislative facts that the legislature had? Well, I can't tell you, but at least we can sharpen the trade-off. Let me explain. I'll give you one more example to try to explain the trade-off with a little more precision. Think about the Riggs case. So sure, we think, when the legislature enacted the law, the statute of wills, they never thought of murderous heirs. When the judges got the case, they realized there were murderous heirs. So now you might say, this is a case where the judges, not only do they have the adjudicative facts, they see the case, they know the details, but they actually have better legislative facts. Because now the judges know something that the legislators did not realize when they were crafting their policy, which is that there are, in fact, people in the world who will kill to inherit. It's not just this case. There may be other people. The world is full of crazy people sometimes, you know. Okay, so Riggs is maybe a case where you say, yeah, the judges here have better legislative and better adjudicative facts. So this is a case where making an exception to the law really is warranted. And that's what they did. They said you can't inherit. But here's the problem. Even here, we can't know if that's true. So legislators might have reasoned this way. Well, they enact the statute of wills. They don't think about the problem of murderous heirs. But they might have reasoned a different way. The judges might have said, or the legislators, forgive me, might have said something like this when crafting their statute. They might have said, you know, we don't want people who kill other people to inherit. So let's include in the statute some language that says murderers can't inherit. But then those legislators might have said something like this. Oh, but this is quite complicated. What if this person kills that person in an act of mercy? This person is elderly or unwell, and this person, it's euthanasia, assist me in dying. Okay, well, the law might treat that as murder. Euthanasia is not allowed in many places. But in addition to punishing this person for murder, do we want to deny them the inheritance? This person wanted that person to kill them. The legislators might have reasoned like this. We make mistakes. Sometimes we say this person murdered that person, but we're wrong. Somebody else committed the crime. Every legal system in the world makes mistakes. There are always some. Okay, so that's unjust. We're punishing you for murder when you didn't do it. Do we want to compound the injustice by saying, also, you can't inherit from the person you didn't actually murder? Okay, so now the legislators I'm envisioning might have said, the problem of murderous heirs is actually quite complicated. And now when we think about all the various trade-offs, we think the best decision is don't address this problem instead. Well, if that's how they thought, then those legislators really did have better legislative facts. And the judges don't have the advantage on both legislative and adjudicative facts. And so the argument for making an exception is harder. Okay, again, I know this is a little disappointing. I don't have an answer for you. But I think economics with some of this framing, some of this language, it can help us make at least some progress in studying the problem of interpretation. Okay, with a little bit of time, so those are my facts. Okay, with just a little bit of time left, let me just mention a couple of final topics. So the book spends quite a bit of time on judicial deference. So this is a very important question in public law. It comes up in many, many circumstances. So the judges have to make a decision after someone else has made a decision. So for example, it could be these judges are reviewing a decision by an administrative agency. It could be these judges are reviewing a decision by another court, so on. And the question is, when should the judges defer to the first decision maker? And when should they make their own choice? We don't care what you said. We think we know what is best. This issue comes up all the time, and the book spends many, many pages on it. In just my brief discussion here today, I'll run through a little bit of this. So let's start with this question. When do judges defer to other institutions? This is both a positive question in practice, when do the judges defer? And you can think of it as a normative question too, when should they defer? As opposed to doing it themselves. So there are many things you could say here. In the book, we try to reduce it to a couple of basic but important concepts. Information, this relates to the last topic, and values. If the decision maker that came first has better information than the court, and if they have the same values, we're aiming for the same objectives, then of course you should defer. You have the same goals and they know better than you, so you follow their decision. If you, the court, you have better information and you have the same value, then you should decide. We're all aiming for the same objective, but we know better. Okay, the challenge arises, of course, the version of the same trade-off we just discussed with justice. The problem arises when they have better information, but you don't share values. So it could go the other way too. So this is a fight we have in the United States with regulatory agencies all the time. The basic idea is this: yes, they have the expertise on antitrust or on securities or on the environment. They have the expertise, but they're a bunch of corrupt bureaucrats. I'm not saying that's actually true. This is just what people argue, right? You can't trust them. Whereas we, the court, we are just doing the public's work, public good. Okay, so what do you do in this circumstance? And obviously, people disagree. We can state the trade-off abstractly. The question is whether, judge, if you act you're losing the benefits of the information, but you're gaining your own values. You're promoting your own values, and the other way around. Okay, so as a positive matter, we think this basic trade-off can help us understand when judges do and don't defer. And normatively, it's a question of these two costs. If there are good reasons to think the judges really are pursuing the public interest and the agencies are not, you should defer less. But of course, it could go the other way. You might think the judges are, I don't know, politicians, or they're captured, and the agencies are the experts. And okay, so there's no way to answer the question in the abstract, but case by case with detailed information, you can make some progress on it. Let's talk about another version of the judicial deference question. When do lower courts defer to higher courts? So we were just talking about this before we started today. In the United States, we have a strong system of precedent. So if the higher court says the statute is ambiguous, could mean this, could mean that, then the higher court makes a decision and says statute means X. Well, now the lower court is bound by that precedent. They get another case about this statute, it means X, because the court told us so. That's the idea. In practice, it doesn't always work this way. Of course, if you read the cases closely, sometimes the lower court, oh no, I can distinguish the other case. So the precedent doesn't bind me. I can do my own. I can make my own choice. So in the book, we have some very simple graphs, no math, to try to help capture this dynamic. And I'll just talk you through one graph from the book. So the question is, what does the statute mean? Could be any statute. The closer you move to the left, that means you're giving a narrower and narrower interpretation of the statute. It doesn't regulate so much. Farther you move to the right, you're giving a broader and broader interpretation. It means many things, or it regulates many things. And now we just assume that the Supreme Court, S, prefers a different interpretation from the appeals court, which is below it, A. So if it were just up to the Supreme Court, they would say the law means S. If it were just up to the appeal court, they would say the law means A. It's more complicated than that. The appeals court has to decide what the law means, knowing the case will then go to the Supreme Court. And they may defer to you, or they may say, we don't care what you said. We're going to choose our own interpretation. Okay, so how does this strategic game play out? Well, it depends on maybe this is obvious, it depends on the capacity of the high court to monitor and punish the lower court. So if the higher court sees everything the lower court does and can easily punish them, then if you're the lower court, you should make the interpretation S. That's not the one you want. It's the one the Supreme Court wants. But if you choose anything else, they will punish you, and you don't want to be punished. On the other hand, if the Supreme Court has no capacity to monitor or punish you, you just make the interpretation A. That's what you want, and it will stick. Of course, the interesting case comes when the higher court has some capacity to monitor and to punish you. Okay, we capture that possibility with that dark bar on the bottom that's labeled tolerance interval. There's more details in the book, but the basic idea is if you set the interpretation close enough to what the high court wants, they will live with it. Not because it's their first choice, but because disciplining you, changing the law, it's just too much work. So they will tolerate anything in the interval. So now if you're the lower court and you're strategic, what interpretation will you choose? T for the tipping point. It's as close to the interpretation that you prefer as possible without triggering some punishment from the high court. So this is just a positive analysis. We think it's helpful for when we're watching the judicial hierarchy operate. When do they defer? When don't they? Well, we think these simple models can be quite helpful. Okay, one last topic here. When do judges defer to co-equal judges? So two examples to motivate. In the United States, we have many federal courts of appeals, and judges on those courts decide in groups of 3. But the court is much larger. So for example, long ago, I lived in California. California's, the Ninth Circuit Court of Appeals has jurisdiction over California. It's a huge court, over 25 judges. But all of the cases are decided by groups of 3. So judges A, B, and C decide this case, and they set a precedent. And now judges X, Y, and Z get a similar case. Do they have to follow the precedent of these co-equal judges, or can they do what they wish? They don't have to defer. Well, in the book, we consider this scenario through a very simple game theory lens. It's a kind of prisoner's dilemma. You're probably all familiar with this. So this is the example from the book. We're imagining 2 judges, Shu and Willow, and these are ABC versus XYZ, right? And they each have to decide whether they want to follow the other one's precedent, defer to the other judge, or the English term for this sort of informal is buck the precedent. So I will do what I want. I don't care what you said, what you think I'm supposed to do. And so now we have different equilibria. Each one could follow the other's precedent for payoffs of 3 apiece. Each one could ignore the other's precedent for payoffs of 2 apiece. Or we have the corner solutions, and you can understand the payoffs. If you're Judge Shu, the best possible outcome for you is if you ignore Willow's precedent, you do what you want, but Willow follows your precedent. Then you get everything you want in both cases, and the other way around. Well, this is a standard prisoner's dilemma. And if you run through the analysis, you will see that the equilibrium is for them both to buck precedent. Nobody follows, nobody defers, and the way we've set this up, that's not the optimal outcome. Okay, so now this leaves us with a puzzle. If the equilibrium is nobody follows anyone else's precedent, why in the United States and some other countries is there such a strong system of precedent? Maybe the answer is obvious, but this is a one-shot interaction. And with repeat play, we can get to the cooperative equilibrium. Another simple way to put this in law and economics terms is if the judges can bargain easily with one another, they will find their way to the efficient outcome, see the Coase theorem, which we talk about a lot in the book in public law context. Okay, so in the long run, they may agree, listen, I will defer to you today if you will defer to me tomorrow, and we go back and forth, we strike this deal. And this kind of cooperation helps to explain why precedent operates so strongly in the US, even though there's really no enforcement mechanism. There is no natural way for some higher authority to come in and say, you must do what that judge said. There's no easy way to do that. Well, maybe I should give you just to help see the generality of the analysis. So far, I've talked about this panel of judges that's working today, following the precedents set by that panel of judges that's working today. But there's another version of the very same issue, which operates not across in this fashion. It operates across time. So today's Supreme Court in the US gets cases, and they have to decide, should we do what we want, or should we follow the precedent set by yesterday's court? A bunch of justices who are no longer there. They may have passed away, they're retired, whatever. Well, you can imagine the same kind of dynamic unfolding. If we ignore the old precedents, that's good for us today, but what will the next generation of judges do? Well, they will ignore all the precedents we created. So you can get a kind of cooperative, repeated play equilibrium, where we follow their precedents so long as they follow ours. Okay, of course, this can break down. Probably all familiar with this. The basic, again, it's deliberately simple game theory so that it's digestible for people who have not spent years studying game theory and calculus and so on. This simple but powerful theory tells us, look, repeat play can lead to cooperation until you know the end game. As soon as you know when the last round of the game will be played, all the cooperation can unfold. Okay, well, this is a hard problem. In principle, the judges, of course, don't know when the last round of the game is. They don't know when their courts will cease to exist or the country will cease to exist or something along these lines. But anytime there's a risk of that or any possibility of that, now we worry. Cooperation is going to start to break down. System of precedent fail. Okay, last topic, I promise. Is stare decisis a good idea? So much of what I've just walked you through in the last 5 minutes or something is a kind of positive analysis of when we think a system of precedent will catch, when it will take hold, when judges will follow precedents or defer and so on. Is a system of precedent a good idea? Well, I understand you don't have much of such a system here. It's common in civil law countries. Well, there are many things you could say about this topic, and I'll just mention a few. So on the one hand, following precedent can lock in errors. And I should have added another word here, legal errors. So here's what I mean by that. If the correct interpretation of the law is A, but the first court that got the case said B, well, now with a system of precedent, the law is B. So it was wrong in a legal sense in that first case, and now that error will persist into future cases. So that's the problem. But of course, there are upsides to stare decisis is the Latin term we use in the US system of precedent. Okay. On the other hand, it saves decision costs for judges. I didn't appreciate this until I worked for a judge in the United States. I was astounded. He was juggling 80 cases at any given time. And this is an appeals judge. So these are long, complicated cases, long records. Okay, if you can follow a system of precedent, rather than trying to generate an original interpretation in every case, you save a lot of time, a lot of decision costs. That's not just good for you, but it's good for the parties. Time is valuable. This speeds things along. Of course, stare decisis can make law more predictable. And this is the standard and I think most powerful justification for such a system. Do you want to know how the law applies to your case? Just look at the prior cases. You might read the statute first. The problem is the statute's often ambiguous or vague. Read the prior cases. What they decided, that helps you understand what will come up for you. Here we can think of the Coase theorem again. Especially if you're thinking of regulations of private actors. The Coase theorem tells us, look, if they can bargain with one another easily, they will achieve efficiency on their own, and the law doesn't matter. Okay, well, let's apply that to the concept of precedent. Maybe the judge got it wrong the first time. We've locked in an error. But as long as that doesn't change, the transactions cost might be relatively low. Right? If the law is changing all the time, obviously that's raising your transactions cost. It's hard to negotiate around a moving target. Okay, so predictability is valuable. You can plan. In economic terms, it lowers transaction costs. Of course, there's a difficult question that lawyers have to confront, which is what counts as a precedent. So if you have a case about an automobile accident and a precedent is set. Now, the next week, you get a case about a boat accident. Well, does the case about cars govern the case about boats, or does it not? Do you have to decide anew? This is a very old question that has been debated over and over. In the extreme, no two cases are ever the same. At a minimum, they happened at different times. And as a consequence, you can always say this is not a precedent for that. Okay, well, we have a little discussion of what counts as a precedent in the book. That is to say, when are you bound by the prior case and when are you free to do something new? And we rely on the same kinds of values and considerations that I've just talked you through. One way to think about whether to decide anew or follow the precedent is whether to make an exception or whether not to. If you decide anew, that's like making an exception. And if you follow the precedent, it's like following the law. So now we can draw in some of the same considerations we went through: communication costs, legislative versus adjudicative facts, and so on. Okay, that's everything I've prepared. It's a little bit of a scatter shot. There's much more in the book. Hopefully you want to read it. And instead, after this, you may be like, no, I never want. We try systematically to go through lots of topics that we think will be helpful to public law. We try to make it accessible. Oh, and here's a maybe final important point I want to make. We try very hard to make the material relevant to the work of lawyers and judges. So one of the challenges here, I guess I should have mentioned this at the beginning, is that a lot of analysis that you might think, yeah, I think of that as public law and economics, it's really about the design of legal institutions. How many chambers should the legislature have? How many judges should be on the court? How many layers should there be in the judicial hierarchy? I'm very interested in the design of legal institutions, but most lawyers and judges are not. Not because these are not their cases. This is what they don't design regulatory agencies. They give legal advice. They answer legal questions. So to try to make the book relevant to lawyers and judges, we've spent a lot of pages on interpretation. We try to think about real cases, real decisions lawyers and judges have to. Thank you so much for coming. Thank you for your interest. I hope you find the book helpful. And I don't know if there's time for questions. If there is, I'm happy to take. Thank you.
Hey, well, thank you, Michael, of course, for the wonderful masterclass, and especially considering that it was only 5% of your book, so the other 95% is also very, very interesting. My question is about intentionalism. Would you say that is, I would like to understand how it works in the United States. Would you say that is closer to what was in the mind of the, I don't know, 5 or 10 congressmen that drafted the law at the day of its discussion in Congress, or closer to what common sense in the actual society thinks about what's that idea in the present?
Yes, it's an excellent question. I'll be brief, I promise. I've already gone too long. There are 3 versions of intentionalism. So version 1 is, what were the actual legislators who enacted the law thinking when they enacted it? The second version, probably the most common, is we have no idea what they were actually thinking. What would they have thought if this issue had occurred to them when they were drafting the law? This is where intuition comes in, of course. And then the third version is to say, we don't know what they were thinking. Maybe they weren't thinking anything. What was the purpose of the law? Just what was the big objective of this law? And now we'll decide the case in a way that we think furthers the purpose. So I think each of these conceptions of intentionalism is defensible, but they also add complications. There are just many ways to try to do this work.
I have a little question about your approach. You mentioned that the problem is designing institution, basically, in terms of general terms. You use the game theory here. In game theory, when we design institution, we talk about mechanism design. It says, do you have in your book some mention about designing institution as designing games, basically? Is this approach?
Yes, but only in a soft way. So the phrase mechanism design does not appear in the book.
Okay, but the concept.
Yeah, the concept is there. So as I say, we're interested in institutional design, and so you'll find some of that in the book, but we don't emphasize that.
I guess nobody knows for who they really work for. I come from the University of Chile, and we have a undergraduate class on economic analysis of public law since 2022. Yeah, we're going to use the book now, so it will our work easier than going to Tulloch and all the people. We have a reader that's very complicated, and this will make things easier for us. So thank you for that. My question is, when is the book on institutional analysis coming from? Because I guess it's the next thing after this. You create the doubt, and now you need to make students compare how different things go.
Yes.
I was thinking your example from the information, and whether a judge could say, well, these legislative bodies too entrenched, this is not going to change in 10 years from now. I guess I'll take the decision because if the information cost will be higher now, well, it will be the only way, right, to
Yes.
go forward.
Yes.
So then I think that's in the book, but
Yes.
we need the next version.
Yes. Well, thank you. I'm very flattered. I'm delighted if you'll use the book. I don't know if I ever want to write another book. That isn't quite true. So Cooter and Ulan's, the latest version of the book is the 6th edition, and another author and I are helping the two of them with the 7th edition. So we will write one more. I will write one more book. That might be all. I think maybe we talk afterwards. I think there may be some resources out there on institutional design. I guess the question is whether they're accessible to students. It's often so technical. I don't know if there's a good book.
My question is related to textualism versus intentionalism. How this framework will be used for more complex cases, like when some companies use legal tricks to pay less taxes or something more complicated.
Yeah. It's a good question. I don't know if I can give you a good general answer. I mean, my instinct is that the optimal, from an economic point of view, the kind of efficient method of interpretation depends in an important way on who the regulated parties are. So there's actually an example of this in the book. There's a very complicated statute in the US that no one other than a lawyer would read or attempt to make sense of. It's all about legal procedure, class actions, transferring the case from one venue to another. It has a very important typo in it. They said basically they said less instead of more. And this is very bad. Instead of having 7 days to file your appeal, if you read the text literally, you have to wait 7 days, and then you can file your appeal anytime, including 50 years from now. That can't be the right interpretation. In a case like that, I think the argument for following the text rigidly is strong, because the people reading it are lawyers. They're sophisticated. They know how to read the text closely. In a case like Locke, there may be some lawyers involved, but a lot of people are small miners just trying to do their paperwork. I think there you might think, the regulated parties are not so sophisticated, so maybe we rely more on intuition than the text. So in your scenario, I'm imagining quite sophisticated regulated parties. Just do what the law says as best you can.